So I want to start with the concept that every Indian child matters. And the reason every Indian child matters is because of the past practices and policies of the federal government. And those policies have rippled forward that led to the passage of the Indian Child Welfare Act. And what the Indian Child Welfare Act recognizes is that not only is it in the best interest of Indian children, but it also recognizes that it is a remedial statute that is designed to prevent the extinction of tribes. And I say that in the sense that tribes as a culture, not as a racial group. So one of the things that you hear in the media over and over again recently, in the last basically 3 years, is that ICWA is an impermissible racial statute. And I want to reiterate over and over again, it's not a racial statute. It's based on those cultural connections that people have with their tribes. So if you take the children away, you are contributing to the extinction of the tribes. And that's the piece that I think gets missed over and over again. So here's some information that you're going to get over the course of the next 2 days, but I want to start out with this. So according to NCWA, Indian children make up approximately 9% of Montana's population, but represent 38% of foster care children. So I want to stop and discuss this a little bit, because when ICWA was originally passed in '78, the percentage for Montana was about 24%. So we're not going in the direction that we'd hope we'd be going with the passage of ICWA in '78. We now have more children in the foster care system here in Montana than we did when ICWA was passed. So I don't think it's because there are more problems. I think there are some other factors going on in regards to that number. In Montana, Indian children are approximately 4.1 times more likely to be in foster care than white children. Again, I don't think this is because the problems in Indian family are greater. I think there's something else going on. And nationally, since 2009, Indian children have had the highest rates of representation percentage-wise in foster care, according to the Administration for Children and Youth and Families. Those are pretty outstanding numbers when you think about it, that you have that many children in foster care. Those are children that are not going to be in their tribal communities often. So what's at stake? What are the losses when those children are not placed with their communities and families? The big loss, of course, is going to be language. And we see that with the decline in your tribal languages. Ceremonies, those ceremonies that we heard this morning when the chairman came up and did the introduction here, those are going to be lost if the children do not have exposure to that. That knowledge, that inherent knowledge of plants, of seasons, of healing ceremonies, those are all going to be gone. Historical perspectives are also going to be gone. Part of what we see happening is that the idea that tribal perspectives are not included in the educational system has an effect on what information is given to children, not just Indian children, but all children. So that historical perspective can be lost. And then there's the big one, which is lives are lost. And that is one of the factors that comes into play when you're looking at where you place kids. So languages, here's just some brief information on languages. Indigenous languages around the world are being lost at an alarming rate. It's particularly significant here in the United States. National Geographic does an Enduring Voices project, and as part of that, they are indicating that more than half of the indigenous languages on Earth are going to be lost, and that knowledge will go with that. So that is a factor to keep in mind. In Montana, most of those losses represent the indigenous languages here in Montana. Several of the tribes in Montana have less than 100 fluent speakers of their language. So why is language important? Why do you want to preserve language? You want to preserve it because that's how you preserve your culture. That's how you pass on that information. That is how you define your world. So when Chairman Finley talks about welcome to the homeland of the Salish Kootenai people and the Pawnee people, he's talking about preserving that culture, and he's talking about preserving language in particular when he gets up here and he does the presentation in his tribal language. That oral information that's going to be passed down is going to be lost if you don't preserve those languages. And that is also a factor that ICWA can help prevent. The ceremonies, birthing, naming ceremonies, those are not going to be passed down. That information won't be passed down if you don't have that generation to pass it down to. Puberty ceremonies, that's also going to be lost, and those vary from tribe to tribe. Marriage, what goes into marriage? What are the ceremonies that are associated with marriage? That is going to be lost. Healing ceremonies, not only physical healing ceremonies, but those spiritual healing ceremonies are also going to be lost. And that spirituality that basically is infused throughout tribal culture, that's going to be gone if you don't have that generation to pass it on to. The ceremonies surrounding death and how you deal with death within your Indian communities, that is also not going to be passed on without those generations. Education. Education is a huge factor in looking at not only how we got to the place we are with Indian families, but also in what's happening currently. So in Montana, 13.5% of students in the public education system are American Indian. So that's higher, as you might notice, that is higher than the percentage in the population. So that should indicate right now you have a very young population of American Indian children in Montana. It's almost double what the statistics are for the general populations. They graduate in a rate from Montana high schools, and this is the most recent statistic I could find, of 62.9%. So you often have them not graduating from high school. There's a significant number that do not graduate from high school. What are the consequences of that? The consequences are going to be employment issues. They're going to be whether they are able to have housing that is adequate, whether they have the resources to care for children, and the ability to basically meet the needs of their family. Dropout rate for Indian students in Montana high schools, 7%. And then you have the history. So how many of you guys are familiar with the Kennewick Man, the recent developments in Kennewick Man? I always find this very sort of ironic, is that, 10, 15 years ago now, when they discovered Kennewick Man, the tribes in that area said, we claim this individual. He's one of our ancient ones. We know he didn't look like us, but he's one of our people, and we claim this person, and we want to repatriate him. And the anthropologist and archaeologist and everybody came in and said, oh, no, 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 this can't be an Indian person. This doesn't look like an Indian person. This isn't an Indian person. You can't claim him. And they got the courts to agree with that. Now the irony is, the very person who was challenging that has now discovered that in fact, oh, guess what? This is an Indian person, and they're fairly closely related, I believe, to the Colville tribe, which was one of the original tribes that was claiming the Kennewick Man. So that historical knowledge is there, but it's often ignored. And I think that Kennewick Man is a perfect example. I got lots and lots of emails when the information came down 2 weeks ago or 3 weeks ago saying that Kennewick Man actually was Indian, because that's what the tribes have been saying all along. The other story along the education, the history piece of it, is Sir John Franklin's ship that went missing in the Arctic Circle, and the tribes in that area had stories about the ice ship, and they would tell them, and they would basically be ignored. And lo and behold, as we get the climate change effects and you have the ice melting, the ship appears exactly where the tribe said it was in the stories that they were telling. So tribes have history that's often ignored, that as time goes on is determined to be very accurate. That history is not going to be passed on. Those stories cannot be passed on unless you have the children to pass them on to. So what are the issues? The other issue is what happens to Indian children. According to the Center for Disease Control, suicide is the second leading cause of death for American Indian and Alaska Natives. That is huge. And that is a factor that led to the original passage of the Indian Child Welfare Act, was the high rate of suicide among children that were removed from their families and were placed particularly in non-Indian families. So suicide is still a problem. Among adolescents children between the ages of 15 and 34, it's 2.5 times higher than the national average. That may not, number-wise, that may not be a lot, but it is still a significant figure when you look at the increase in suicide rate. The other piece that comes with children in the foster care system is that prison system, that pipeline to prison system that is created by that. If you look at the statistics, the incarceration population of American Indians is greater than in the other population based on their percentages. In Montana, the incarceration population is about 22% greater than their population in Montana. That statistic is somewhat skewed, however, because if you just look at the women's prison, it's in the 38% range, is the percentage of Indian women that are incarcerated. So what happens when you have an Indian woman that's incarcerated? Most likely that Indian woman is going to have kids. I can't tell you that they all do, but I've had several of my clients that have been in the system where their children, are we?
Yeah, you're fine.
Okay. where their children then are in some kind of foster care system as a result of that incarceration. So that 38% of women is actually going to skew this factor here, and you're going to have more children in the system because of those women that are incarcerated. If you look at those women, the women that I've dealt with, a large percentage of those children, of those women, were in the foster care system as children. So that's that pipeline. So incarceration is a huge factor in looking at how ICWA comes into play and how you deal with that. So ICWA is going to be important in all of those areas that I talked about. It comes into play in your education, it comes into play in the suicide rate, it comes into play in the prison system. And looking at how you can reduce some of those problems and reduce some of those impacts is through compliance of ICWA. So I'm going to go through some scenarios here that will talk about how you can possibly break the cycles that lead to children being removed from the families. So the first case I'm going to talk about is a CH case. This case actually did end up before the Montana Supreme Court. Fortunately, not many of my cases do. They're addressed at the lower level and they never make it to the Montana Supreme Court. But CH was a case, and I always say this is the case I became involved with because the clerk for the court had gone to law school with me, and so she called and said, there's a tribe from Oregon that needs representation in this case. It should be a fairly simple case. Would you represent the tribe from Oregon? And I said, sure. And then 3 years later, when I'm in before the Montana Supreme Court, I think this really was not a simple case. So CH, here's the background on CH. It involved a 3-month-old child. This 3-month-old child was removed for physical injuries. We never contested that this child should not have been removed. That was never contested. The tribe didn't contest that at all. We felt the child should have been removed, and it was not in Indian country. It was in an area outside of Indian country. At the time the child was removed, there was an attempt to locate extended family because there was some indication that this child was potentially an Indian child. The great aunt who lived in Oregon and her and her husband were a licensed foster care family for special needs children in the state of Oregon. They contacted, when they found out that this child had been removed, they contacted the state. That is pretty remarkable to have a family come forward that soon. So that's one of those things that this makes this case a little unusual, is you have extended family coming forward fairly soon in the process. The child had been in foster care about 7 weeks when the extended family came forward. And they asked for placement of that child with them. The child ended up being 3 years old before we achieved placement with this extended family. So you have to say, why? We have a licensed foster care family for the state of Oregon that the child is not being placed with. So what's going on here? I have to tell you, my first conversation with the county attorney in that case was, he called me up and he says, we have this case that involves, I guess, this Indian child, and I understand there's some federal statute that may impact that. And we need to figure out a way to avoid having to comply with that federal statute, because this child is with a wonderful foster care family in town here. I sit as the board of directors for their foster care home, and they want to adopt the child. So we just need to figure out a way to not have to comply with that federal statute. So that was my first clue that this probably was not going to be an easy case, right? And as a result of that attitude, it wasn't just the prosecutors, it was throughout the system, you ended up with a very, very difficult case. And the district court, in its findings, said that there was good cause to not comply with ICWA. And what the court did is it looked at competing factors and balanced those competing factors and determined that clear and convincing evidence, it was for allowing the child to remain with the foster family that the child had been placed with when she was removed from the parents. Along those lines, I will tell you, initially the tribe requested to transfer this case, and then the state said, well, we'll place with whoever you want us to. So the tribe withdrew its request to transfer, and subsequent to that, the state elected not to comply with the tribe's request. And there was a case that came down called AP right like 2 weeks after I'd filed the motion to request, that says you don't have to transfer if parental rights have been terminated, that it's far enough in the proceedings that you don't have to transfer. The prosecutor had got the parents to voluntarily terminate their parental rights in connection with a plea agreement in regards to the initial charges. Now, I wasn't representing the parents. I question whether that's voluntary if it's with a plea agreement, but that's how the parental rights were terminated, and the state no longer had to transfer because of the AP case. So you often will have situations that come up where something will impact your case that you have no control over. So what the court does, the district court, is he does this list and he lists out why the child, what the benefits were for continuing the child with the foster family. And he talks about that the child had healed in the foster care home, and that there was hopeful prospects for emotional healing, and that the foster family had experience with abused children, and that by keeping the child in the foster care system or in the foster home, there wouldn't be any separation or change in that child's life. So it's this idea of bonding, that you don't want to create additional trauma to the child. Then there's this whole idea of attachment disorder that the court relied on for saying, if I remove this child, the child is likely to suffer from attachment disorder and have long-term ramifications for that. And then the idea that the foster family was going to protect this child from the family that was in that town. Obviously, the family's parental rights had been terminated, but they were concerned that the extended family would allow contact between the biological parents or the grandparents, and the court was trying to protect that. The thing that worked against the foster family is they acknowledged that the child would have very little exposure to cultural events and culture, particularly of the Siletz tribe. The foster family did indicate over and over again that they would take this child to powwows, but that was the extent of what they could offer for cultural exposure. Then there was some indication that the child may have fetal alcohol effect issues. I will tell you that I think that information was really slight. There was really nothing to indicate she was small for her age, and that's what they were basing it on. But developmentally, there were no issues, but that was one of the things that the court looked at. And then they felt that because of the bonding, adoption would be easier with the foster family than removing the child. Cultural issues, that was one of the things that the court said there may be some issues there with the foster family because they don't have that, but when looking at everything overall, they didn't think that was going to be a problem. When they looked at the extended family, all they could find is that the extended family promised to continue healing. So I have to tell you, this was an extraordinary extended family. If you have to have an ICWA case, this is the kind of extended family you want. And that is that this family lived in the Portland area, outside of Portland. They came over every 6 weeks for a 3-day weekend to have visitation with that child for those 3 years. They only were allowed supervised visits, so it was limited contact, but they did that for a total of 3 years. So it was a very extraordinary extended family because they had the resources to do that. And many extended families are not going to have those kind of resources to make that kind of effort. They said that the court said that they lacked experience dealing with special needs children, which I found interesting in light of that they were licensed as a special needs foster home in Oregon. And that by placing the child with them, it would create emotional trauma for the child. There was going to be an increased risk of long-term problems with the child by placing him with him. And again, this exposure to that hostile family in the town that was where they were located. They did acknowledge that the child would get exposure to the tribal culture, but they didn't think that that was going to be significant enough. And all the extended family could do was to hope to cope with the effects of the attachment disorder. So those are what the court looked at. This is directly from the order, by the way. I have not changed any of those. And the court found, based on that there was good cause to depart from the placement preferences based on the extraordinary physical and emotional needs of CH. Along the same line, or at the same time, the biological mother had gotten pregnant in the interim time during that 3-year period. And she actually went to Oregon to have the child so that the child could be placed with the extended family in Oregon, that the state of Montana would not be involved with that. One of the problems we had with this case is that repeatedly the social workers kept saying, well, we're having a hard time complying with ICWA because the child doesn't look Indian. And that was a repeated comment that we got. Now, I sort of have to do a shout out to Kathy Deserly, who was the ICWA specialist at that time and kept telling them, you need to comply with ICWA. To no avail, we might add. But it wasn't that they didn't know that they shouldn't comply, it's that they did not want to comply. And I see this over and over again. It's not that I think the state courts, the social workers don't know about ICWA, is that they just emotionally don't want to comply with ICWA. And I think that's what makes these cases so difficult. So it goes up to for the reasoning is the presence of the healing home and looking at how that foster family can heal the child, and the attachment disorder that the court thought the child was going to suffer from if the child was moved from the foster family to the extended family. And this was the other one that they used, was the unusual length of time the child had been forced to remain in the foster home. And the fact that this child was deemed high risk because of all of her misfortune. So they found that the foster home was going to be the safe, secure, and stable environment for the child, and as a result, that the child should remain with that foster family. So the Montana Supreme Court looked at this, and I, just as an aside, I will tell you, the county attorney asked for 2 continuances to file his responsive brief in this matter. So we extended the time out for about another 6 months from when we filed the appeal. So this is one of the things that did happen, I think, as a result of this case, is once everything got submitted to the Montana Supreme Court, the Montana Supreme Court then issued an order that in dependency and neglect cases, you can't ask for extensions of time unless there are extraordinary circumstances. And probably moving to a new house, and just because you can, we're not going to be extraordinary circumstances in that regards. The court said there was no good cause to deviate from the placement preferences. And the placement preferences were real clear that the child should have gone to the extended family. So possible problems are not sufficient grounds. Saying this could happen is not sufficient grounds under ICWA. Under ICWA, you're going to have to show that there's actual damage to the child, that something is currently a problem, and they're going to really limit when you can deviate from that. So one of the things that they said, that if bonding has been created by state actions, you can't use that to deviate from the placement preferences. And that's one of the things that have been happening is if you can delay a case long enough, you're going to have a child that's been in a foster care home for an incredibly long time, and then you can use bonding to say, and we need to keep that child there. And the Supreme Court said, no, you can't do that. That is not sufficient. And in reality, bonding, that's something that if a child has learned it, they can replicate it. And in this case, the child had learned to bond, and the court said, there's nothing to indicate this child can't replicate that bonding with the extended family. So I will tell you, this case is important for the extent that it recognizes that the criteria for deviating from the ICWA placements is extremely narrow. So when it talks about extraordinary physical and emotional needs of a child, that means that those needs cannot be met in the location that the extended family is. Those services are not available for that. It seemed unlikely that the services, the medical services, the counseling services that this child might need were going to be more available in a town in Montana than they would in the Portland area of Oregon. So the court said that is not going to be sufficient. That doesn't mean that there could not be circumstances where the needs of the child are so significant that you do need to place that child someplace where those services are available. And that may be with a non-Indian family. What the Montana Supreme Court did is they said that bonding by itself is not going to be sufficient, particularly if you create that bonding. This is the case that they used in the Baby Veronica case, the lower court, when that case first came to them, and they used that for justification for placing Veronica with her father. So this case has been used by other jurisdictions in looking at that bonding issue. One of the other factors that I will tell you is there was all this concern about the transition after that child had been with the foster family for 3 years, on how that transition was going to happen. And so we had this transition plan that was going to be a gradual transition, and the foster family agreed that they would facilitate this So the extended family came to the Montana town and stayed there for 5 days and had access to that child for the first 5 days. And then the next time they were going to be, I believe it was in Spokane, where they were going to meet and have a transition. And the first night there, CH said to the foster family, "You can go now, I'm fine." And so that transition that was going to be so horrendous did not end up being as horrendous as they had anticipated. So I think that points to the resiliency of kids, and I think it also points to the importance of extended family, and that bond is going to be there with your extended family whether the child is placed there or not. And keep in mind, she had a full blood or a full sibling with that extended family by the time she was placed with them. So this is sort of a happy ending case for me, but it did take 3 years. And I think of how much better it would have been for that child if that child had been placed there within that first 7 weeks. I have a question back there.
Yes, Maylinn, would you talk about whether the Montana Supreme Court was interpreting federal law and whether that decision of possible repercussions, whether that's been upheld by a federal court?
Well, these cases rarely get into the federal court. This is based on the Indian Child Welfare Act. The Montana Supreme Court looked at the Indian Child Welfare Act and said, no, when it says good cause to deviate for extraordinary physical and emotional needs of the child, this isn't what they mean. They don't mean bonding that is a result of non-compliance with ICWA by the state. They don't mean possible problems in the future. It has to be something that currently is happening that has to be met with a specific placement because of the extraordinary emotional or physical needs of that child. It's not going to be something that may happen. It's got to be something concrete. So it's based on ICWA. Well, that's always the problem with ICWA, is even though you're supposed to have uniform interpretation because it's a federal statute, you do get variance from state to state. Montana has a mixed history, I guess is how I say. For a number of years, I think Montana did very well in interpreting ICWA in accordance with what the intent of ICWA is and following that spirit of ICWA in the Supreme Court decisions. I wouldn't say they've been as good in probably the last 10 years or so. So I think it depends on who's on your court, and it depends on their level of understanding of ICWA and the intent of ICWA. So I think that you're going to get variations from state to state for sure, depending on how they look at that. And that's the problem. That's one of the problems you have with ICWA, is that there's not uniformity, even though it's a federal statute on that. So now I'm going to move on to what I refer to as probably my never-ending ICWA case. I've had this case for 10 years, actually more than 10 years now. This case started with mom who was quite young. She was 16 when she had her first child. She'd been in the foster care system herself off and on. So I think this is an example of where you have foster children who then end up being part of ICWA as parents. She ran away from the foster care. She did not have a very stable home life for sure. And when she had her first child, like I said, she was 16. She was barely, not quite 16 and 9 months. So we sort of wondered. Father was 10 years older than her, of this child, and nothing was ever done in that regards. So I think there's some issues there. Mom has significant addiction issues and mental health issues, and she has, probably from the time she was a teenager, because she probably never got the services that she needed when she was in the foster care system. So she self-medicates and the mental health issues by a variety of substances. As part of that, she got involved with a group that were associated with a murder and resulted in her being an accomplice to it. Even though she wasn't present at the actual murder, she helped clean up. So that always makes it a challenge when you're representing these. So as a result of that, what we did as representing her is we developed a parenting plan with the biological father, or the alleged biological father, I will say, to give custody of their 3-year-old child to him. So as a way of not having her parental rights terminated and making sure that the child was placed appropriately. After she is released from incarceration, she becomes pregnant again with another child. And this is with a parolee that she was in the same housing unit that she was in as part of the pre-release program with the prison system. And she relapses. Not a huge shock. Relapse is pretty common, but she relapses and the child is removed. Mom is allowed to participate with the child in a Livingston program, but she's discharged from that program when that program determines it can't meet her mental health needs. And that's a huge issue when you're dealing with these. I have yet to have a case, other than the CH case, where I was representing the tribe, but where I'm representing a parent, where there are really not some mental health issues. The mental health issues and addiction issues often go hand in hand. So having a treatment program or some kind of program that will allow the mom to have the child there and address mental health issues is a really, really small number. And they're really hard to find and they're really hard to get into. So one of the things that makes it really difficult is the waiting list for those types of programs can often be 9 months to 12 months. So you can be into a removal 12 months in and still not have an individual in a program for reunification. So the lack of appropriate, culturally appropriate treatment programs is a huge issue in these ICWA cases. Because she's kicked out of that program and we're trying to keep mom out of prison so she can at least parent at some point, the Teen Challenge program in Missoula indicates that they will take her. The problem with Teen Challenge, the Teen Challenge program in Missoula, is she's not allowed to have her child there. So we still are having to find some place for the child. And one of the things that we do is we look at extended family that may be available and we do a guardianship. So we have the child is placed with an extended family under a guardianship scenario. So lo and behold, but immediately after being released from the Teen Challenge program, mom becomes pregnant again as part of that transitional program. And again, mom relapses when she's pregnant and her probation is revoked. Since she's incarcerated at the time of delivery, we had again set up another guardianship with a friend to avoid having the state come in and take that child. So at the time of birth, we set it up so a guardianship went immediately in place in regards to this child. She subsequently suspends her parental rights to the child in a tribal court proceeding. So some tribes allow for suspension of parental rights as part of facilitating the guardianship process and recognizing that even if you terminate parental rights, there's still a connection with those parents, and you might as well recognize that and not terminate parental rights. So Confederated Salish Kootenai Tribe has a provision in their tribal code that allows for suspension of parental rights. And I encourage all tribes to do that, and I think it would be great if the state would get on board as well, but that's probably less likely to happen. Subsequent to that, she has 3 additional children. She's on parole again. She's married to an individual from a tribe in Idaho now. And she leaves that relationship due to abuse when the child is about 3 months old. What she finds out, though, is when she is picked up for relapsing again, that she is, here in Montana, she finds out she's pregnant again. And this time it's with twins. So she's incarcerated again at the time of the birth of the twins. And this time, I don't have any extended family that I can immediately find to place this child with. So what happens is she was allowed release from the court system to care for the twins while they were still in the hospital, because they were born about, I think, 4 weeks premature. So the court allowed her release from that from the hospital, or from jail, to continue to care for the twins. She finds housing, in transitional housing, in a setting that is what I would consider less than desirable, in that it is a converted hotel that the Battered Women's Shelter, YWCA, uses for transitional housing. So she's in a hotel room with 3 children, twins, and a child who is 11 months old. As you might guess, this is sort of a recipe for disaster. Mom is actually, trying to keep things together, but the reality of it is she has like 6 counseling appointments a week, plus meeting with her probation officer, plus going to the doctor checks for the twins. So I think it's not unreasonable to say this mom is a little overwhelmed with the whole scenario. And what does mom do when she becomes overwhelmed? She relapses. So she relapsed, and social services had got notification that there was a possible relapse. I had told social services that they could not talk to my client unless I was there. So they call me and they said, we have a report, we're going over to talk to her, and I said, I'll meet you there. And I get there, and mom says to me, I relapsed on Monday, this is Wednesday. She said, I realized I relapsed, I got rid of everything, I haven't done anything since then. And she said, are they going to take my kids? And I said, you're not going to say anything, we're going to see what they do. I said, they have to show that, clear and convincing evidence that these kids are in danger, and they have to make that call, but you're not offering anything. So they come, mom's there with the kids, she's feeding the kids, and they say everything's fine, and they said, what can we do? And I said, she needs services. And so they said, okay, we'll help you with services. And then they come back the next day, because they still got a report that she'd relapsed, and again, they don't remove the kids because I'm there. And then the third day they come back, they call and say, we're going to remove the kids. And I was not able to get over there before they removed the kids. And they told her, you have to come do a UA before we return the kids. Well, those are the hard situations, because could she refuse the UA? Yes, but she's on probation. So all they're going to do is call the probation officer and have her do a UA, which most likely is going to be hot, right? And so once it's hot, they're going to remove the kids. And so I said, the call is yours. And she said, well, I haven't used for 4 days, I probably am clean. I said, I don't have any clue. I don't know how long meth stays in your system. I have no clue. This is your call. And she says, well, I'll take the UA. Well, the UA comes back hot. We tell them at the time that there's extended family in the state of Washington that could possibly, would possibly be willing to take the kids, all 3 kids. They never contact that extended family. So we go to the court hearing, they still have not contacted the extended family, and at that point, what I do is I say, we're going to move to transfer. So the oldest child had been with a friend in the Missoula area at the time, and the extended family that was in the state of Washington had indicated that we talked to them, and they'd indicated that they would be considered a placement. So we transferred jurisdiction at that point. And at that point, we were only about 3 weeks, less than a month into the system. So there was really no basis for objecting to that transfer or jurisdiction, but I'm going to tell you the social workers wanted the state to object. So that's that emotional bond that I talk about, is these social workers get so invested in these cases that they want to keep the children where they've placed the children. So the social worker in this case was somebody that had gone to the same church as my client, and there was families in the church that were willing to take the kids, and so the social worker had placed the children with those families. And the social workers felt that the children should remain there and not go with extended family. And I could just see this turning into another CH case, where you have extended family that's willing to do it, to come forward and do that, and the state is blocking that. So we transferred it, and the kids have been with that extended family now for about 1.5 years. So again, one of the things that happened in this case is, as you can see, she's had 6 kids, but she's never had her parental rights terminated. And part of the reason that that's happened is because she's had legal representation the whole time. Most parents are not going to have that. Most parents don't have somebody that they can call immediately when their kids are taken. But because we had this long-term relationship with mom, that mom had that ability to access those legal services. And as a result, we have found extended family or close friends, extended family, for these children in every single one of the cases, and they have not been placed in non-Indian homes. So that is the power of using ICWA and having somebody there that's going to advocate for ICWA. So what's going on in these cases, and why do we get such different results in the state when you look at what the statute says? And one of the things that comes into play with this, as much as we would like to think it doesn't, is implicit bias. And the implicit bias is so subtle that you don't even realize that it's happening. One of the things that you see is the disproportionate representation of Indian children is perhaps not the result of actual risks associated with the situation, but of perceived risks. So if you have a family who may be financially struggling, the court is going to take that into consideration as to, are they able to meet the best needs of those children? If you have a family where you have lots of people living in one household, they're going to look at that and say, is this the best placement for that child? So those are perceived risks that may not actually be at harm to the child. And can those perceptions be wrong? So I had a client once that the social worker, he didn't have a car, and he rode his bike a lot, and we were going to a hearing, and I said, would you like me to come pick you up on the way to the hearing? He said, that would be great. So I picked him up, and then the social worker used the fact that I had picked him up to go to the hearing against him, and that he couldn't even find a way to get to the hearing by himself. So they were claiming that he just wasn't competent to raise his child, and that's what they used. And I thought, I would have never even offered to pick him up if I knew it was going to be used against him, because he would have ridden his bike and gotten there. But I thought, well, this is ridiculous. It's raining. He's going to be riding his bike. I'll just pick him up. It was on the way. It wasn't a big deal, but the social worker used that against him. This is the same social worker that had been working with this client for approximately 2 years and had never found out that he couldn't read. So they said, you know, he doesn't do everything that's in his reunification plan. And when I talked to him, he said, I've done everything they've told me to do. And in fact, he had done everything they had told him to do, but they'd never read his treatment plan to him. So he didn't know what was in that treatment plan. We actually, again, I transferred that one to the tribal court as well, because I just think you get a better reception in your tribal courts in recognizing those issues. So I think those perceptions can be wrong, and I think those perceptions are then impacting what is happening with those children. And so how does that implicit bias impact ICWA cases? I have to say that implicit bias is it's sort of the new buzzword. So instead of saying that you're prejudiced or anything, we're now implicit bias is a buzzword. And it refers to those stereotypes that are used when we are making snap judgments and trying to understand what's happening. And it's all done on an unconscious level. We all have implicit bias. So it's not something that you can get away from. Everybody has implicit bias. And they can be both favorable and they can be unfavorable assessments. And how the court looks at that, how your social workers look at this, and how your county attorneys look at this are all going to affect what happens with these ICWA cases. These biases are going to basically be exhibited through the actions that they take. So it's not going to be something that you're going to come right out and say, I don't think the mom should have this child because she's poor, but those are factors that are going to come into play. And you know, it's one of those things you can't say, I'm going to think about this and then avoid it, because that isn't how implicit bias works. And I give you this link, it's on here, I'm not going to pull this link up, but this is a really good link that talks about that implicit bias review, and it's on the flash drive, and it's a live link, so you can pull it up on that. But what are the possible impacts on your ICWA cases when you have implicit bias? And one of the things is this impacts everybody. So it's going to be not only the court system, and it's not only going to be your social workers and your attorneys representing, it's going to be your service providers. It's going to be the probation officers. It's going to be anybody that comes into contact with these families has that implicit bias. And it's going to be based on those early experiences that you've had, and media, and a whole bunch of associated stereotypes. And that is going to impact how those ICWA cases are handled as a result of that bias. So I can't get away without talking about baby Veronica and how implicit bias impacted the baby Veronica case. So is everybody familiar with baby Veronica here? Okay, I see some kids shaking no. So baby Veronica is a situation that it's the U.S. Supreme Court has only had 2 Indian Child Welfare Act cases that they've addressed, and the baby Veronica is the most recent one. Baby Veronica is a case where biological mom and biological dad were in a relationship, and she found out she was pregnant. The biological father tried to get her to marry him, and the relationship ended up falling apart. And as part of that, mom puts the child up for adoption through an adoption agency with a couple from South Carolina. So the baby is, dad is an enrolled member of the Cherokee Nation. The child would be an enrolled member of the Cherokee Nation. When they give notice to the tribe, they misspell the dad's name and give the wrong birth date for the dad. So the Cherokee Nation says, we don't have any record of this child being a possible member of our tribe. Dad is not told, dad is in the military, dad is not told that this is the mom's intent is to place the child up for adoption. Mom sends dad a text message, says, do you want to pay child support, or do you want to relinquish your rights? Dad says, I will relinquish my rights. This is all done by text message, the new form of communication. And mom then terminates her parental rights, and the child ends up going to South Carolina. Dad, when he actually gets notice of it, initially he signs it, but he thinks he doesn't read it and it's not explained to him, and he signs it and then realizes that it's an adoption decree that he's signing, not a parenting plan that he's signing, and he withdraws his consent. So the issue becomes is, should the child go with dad, or should the child stay with the non-Indian adoptive couple in South Carolina? And the lower court of South Carolina looks at ICWA, said, this is an Indian child, we're going to comply with ICWA, the child goes with dad. So the child was about 15 months old, 15 or 16 months old when she was transferred to dad, and then she was with dad for about 16 months as well, and 16 or 18 months, and the Supreme Court ruled that the dad had never had custody of the child, so ICWA didn't apply, and that the child should go with the non-Indian couple in South Carolina. It was all over the media, and that is where this case is now. Baby Veronica is with the couple in South Carolina. So the Baby Veronica, I think, is a perfect example of where implicit bias really kicks in here. And one of the things that happens is the Supreme Court makes statements about what it means to be Indian. And I think this is one of the areas where that implicit bias comes into play. Is there is this idea that in order to be Indian, it's a racial classification. So there's a statement that if you have like 1 drop of Indian blood, ICWA is going to kick in. And nothing could be further from the truth. ICWA is not, it's not about blood, except to the extent that some tribes use blood quantum to determine who are members or who are citizens of their tribe. So it's a citizenship issue. And I think that's one of the things that if social workers, judges, attorneys, people working with Indian families think of it as a citizenship issue as opposed to whether you're Indian or non-Indian, you have a different framework. If the United States had 38% of their children being adopted out to a foreign nation, I think the United States might be a little upset about that. And I think if their language only had 100 fluent English speakers, I think the United States might be a little upset about that. And they would probably take some actions to deal with that. And that's what ICWA is. So it's not about being Indian, it's about being a member of a federally recognized tribe. So there's a whole bunch of criteria that come into play in determining whether someone is Indian and whether you have an Indian child. And that is that implicit bias that it's not about the fact that she had very little Cherokee blood in her. It was that the Cherokee Nation recognized her as a citizen. That's what triggers the Indian Child Welfare Act, is that membership in a federally recognized tribe. And the Supreme Court had a real difficult time dealing with that. Jane.
Maylinn, do you have any authority on whether or not ICWA applies to non-federally recognized, for example, the Little Shell? We have Little Shell in Great Falls, and they're not federally recognized, they're state recognized.
Right. So the short answer is it's going to depend on what the state says, and it's going to vary from state to state. And Montana has not been consistent on that. I'm going to tell you, part of the time they say yes, Little Shell, we're going to treat Little Shell as Indian children for purposes of ICWA, and part of the time they say no, it's not a federally recognized tribe. So you have both arguments you can make in Montana in regards to the Little Shell. Now, one of the things that you often can do with Little Shell is they may be receiving benefits because they may have connections with other tribes as well, so they may be a descendant of some other tribe that will perhaps trigger ICWA, but Montana's not consistent. Some states, so that's where under ICWA, that is the minimum standards that states are supposed to apply. So a state can have a higher standard. And for example, I just found out that in New York, as part of their ICWA, recognizes any tribe, whether they are federal or state recognized. So it's not just tribes recognized by the state of New York, it's tribes recognized by any state. So that's where it's really important to know what your state position is on that, and it's going to vary from state to state. That's that lack of uniformity that we've talked about. So one of the things that the Supreme Court looks at is they really had trouble saying that this was an Indian child because they kept focusing on her blood quantum, Cherokee does not use blood quantum for determining membership. They're one of the tribes that does not. They're lineal descendancy tribes, and so there's no blood quantum requirement other than that you have to be a lineal descent of someone on the Dawes Act for Cherokee. So she was a citizen of the Cherokee Nation, and ICWA should have been triggered in regards to that. So how do you get around not having ICWA triggered when you have the Cherokee Nation saying this is a member child? Well, then you look at, are they married? And one of the things that the statute says is parent does not include unwed fathers, is what the statute says. If you look at the legislative history, that is qualified based on an old Supreme Court decision, Stanley versus Illinois, that says this does not overrule Stanley versus Illinois if you have a father who is acknowledged, who is part of the child's life, then they still have parental rights. But the Supreme Court didn't even talk about that piece of it. So they said, this person doesn't meet the definition of parent. Well, I think tribe communities would take issue with that in general, that if you are a biological father, that tribal communities are going to recognize some rights in connection with that. And those rights are that biological parents have an interest in that child, and that should not be ignored. And in fact, he exhibited that interest, because after he got notice of the attempt to place Veronica up for adoption, he filed for determining parental, he did a DNA test, determined his paternity, asked for set up a child support, and asked for custody. So he expressed interest basically within 4 months of when she was born, and within virtually 2 weeks of when he got notice of the adoption. So the whole fact scenario of baby Veronica timeline-wise is actually quite interesting, but I don't have time to go through that now, but I suggest that you look at the timeline there. The other thing that I think the Supreme Court shows its bias on, and I'm going to be real blunt here, I think it is impacted by the fact that you have 2 of the Supreme Court justices that have adopted children. So I think there's some bleed over of that process in their decision making, is I think they ignore what the purpose of adoption is about. And I think if you think of adoption as providing children to childless couples, you have a different view than if you think about the purpose of adoption is providing a child with a family. And baby Veronica had a family. She didn't need to be provided a family. So I think the Supreme Court's decision in baby Veronica has a different view of what adoption is than probably what you're going to find in Indian country of the purpose of adoption. The other thing that I think you see in the baby Veronica case is how we're going to treat the rights of fathers. And they took a very narrow view of what those rights of fathers were. And I think this is, for me, baby Veronica is particularly troubling because not only is this a father's rights issue, but this is a father who is in the military service. And so the facts of that case ignore some of that relief that is given to the people serving in the military that he was not afforded in this process. And that's a huge factor as well. Every place I go, I hear ICWA is the gold standard. And I agree. I think every child should have the same rights that ICWA provides to Indian children. I don't think this is a special standard. I think this should be the standard. Every child should have the ability to have contact and to get to know extended families. One of the things we're seeing is the same factors that were coming into play with our Indian children that led to the passage of the Indian Civil Rights, or the Indian Child Welfare Act, is the children who are being adopted from China, from Korea, from other foreign countries are experiencing the same kind of disconnect that the Indian children were experiences that were placed with non-Indian homes. So I think you're seeing that same kind of disconnect there and looking at that. When the Goldwater case, which will be talked about, I'm sure, throughout this process, first came in, I actually sent the link to a friend of mine who is a former social worker for the tribes. And one of the things, she emailed me back and she said, one of the things that she finds so troubling is the challenges, the current challenges being made to ICWA totally disregard the history of what happened to Indian children before ICWA was passed. And the whole idea that the best interest of a child, an Indian child, is compliance with ICWA is not appreciated and is totally being ignored by what the parties are alleging in the Goldwater situation. And what she said is that they, again, non-Indian children in out-of-home placement could actually probably benefit by having the same kind of standards and the same kind of placement preference as the Indian children have under ICWA. And then she looked at the stories of those adoptees looking for their birth parents once they reach maturity. And one of the cases that I had involved a mother who was Crow, and the dad in that case was a Canadian Indian. Child was not enrolled in Crow, and the state was trying to terminate the mother's parental rights, and mother had actually been trying to comply. And she just got so frustrated with the state that she finally said to them, go ahead, terminate my parental rights. I don't care. She's 14. When she gets 18, she's going to come back to me. And I thought, she's absolutely right. They're very short-sighted. And so that's the other thing that I would like to impress is, and Judge Thorne makes a statement, so I'm going to borrow it from him, is you have to look both short-term best interest, but really ICWA is about long-term best interest of your Indian kids. And it's that long-term best interest that I think gets ignored in the system too often. You're looking at immediate needs of the children and not thinking those long-term needs of the children. And that to me is really what ICWA is about, is that long-term best interest. So it's important not only for your Indian children, but it's important for your Indian communities and your Indian families, is how do you think about that long-term needs on it. Best interest, I think, needs to have a broader interpretation than what historically we have given it. And I think that ICWA is really good about trying to guard that. And I think you're going to see that the new guidelines are making that even stronger. So it's not about providing people with children. It's about providing children with families. And that is what the whole purpose is. So what I say about ICWA is doing the right thing may not always be easy, but I think it's essential to heal that damage done to Indian families through past policies of assimilation and annihilation, and it is in the long-term best interest of your Indian children. So compliance with ICWA is a good policy, and it's in the best interest of children. So in concluding, I got several of these sent to me. Did any of you happen to see George Will's opinion on ICWA? So this came out, I think people send this just to see if my blood pressure medicine works. So when he's talking about the baby Veronica case there, but one of the things it says is ICWA forbids blocking placement in an Indian home because of poverty, substance abuse, or non-conforming social behavior. Well, I don't know that any of those things that they're listing automatically mean that you cannot care for a child. Evelyn Stevens used to say, we're not looking for perfect parents, we're looking for good enough parents. And if you look for good enough parents, you realize that people are never going to be perfect. And that kids have their different values to being in families than being in the perfect family. So a lot of what they're complaining about are things that I think could actually be addressed if they were willing to go into your tribal court setting rather than keep it in the state court setting. Most of what they want to do, you can easily do in your tribal court setting. You just can't do it in your state court setting because I think the Congress rightfully recognized that tribal people should be determining what happens to tribal children, not non-Indians in your state court setting. That is not in their best interest.
But aren't children quite often removed because of substance abuse?
That's right.
You put them back in, you put them into another form that there's substance abuse? That doesn't make sense.
Well, but the thing with substance abuse, there's substance abuse where the parents are not able to meet the needs of their child. But there are other substance abuse where they're fully functional. And it's the disparity that you have. Indian kids are going to be removed for substance abuse, where non-Indian kids in homes where substance abuse can be rampant are not being removed. So that's not necessarily the ultimate assessment. It's, are the children at risk because of the substance abuse? Sometimes they are, and sometimes they're not. And just because there's substance abuse does not automatically mean that the child needs to be removed. Otherwise, we'd have a lot of kids in the system if that was the criteria.
You mentioned earlier on kind of the gravamen of the act being that it would be preventing tribal extinction. Is that just dicta, or is that some held somewhere in some case? That's my first question. And secondly, when you're looking at temporary placements in a youth in need of care situation, and there seems to be ICWA involved, is there case law or other regulations that look at protecting the child's relationship with family members who are not Indian?
So absolutely, I'm glad you brought that up, because what ICWA does is it says the first placement preference is with extended family. Extended family could be Indian and non-Indian. So my kids, they're enrolled in a federally recognized tribe, but they have both Indian extended family and they have non-Indian extended family. Fortunately, they're old enough that I don't have to worry about removal. But if they were removed, the courts could look at all extended family. It's not just Indian extended family. It is all extended family. Now, but the caution I make in that is the Act also says unless a tribe has a different placement preference. In Montana, the Fort Peck tribe does have a different placement, and first placement preference is with Indian extended family, second placement preference is non-Indian extended family. So the courts would have to apply that if they had a child that was enrolled at Fort Peck, was a member at Fort Peck. That I'm glad you raised that. In regards to the extinction is looking at the languages, looking at the loss of culture, that the information out there shows about language, in particular, the lack of fluent speakers. Even Crow, which has a really high fluency rate for a tribe, has declined significantly in the last 20 years in the fluency of its speakers. If you don't have that language, you can't pass on a lot of that cultural information. It's gone because it doesn't translate nicely. So I think that is the extinction that you're seeing. It's a subtle extinction. It's an assimilation policy, which there's been a lot of assimilation policies. So it's not that you're going to eliminate them, it's extinction of the culture that I'm talking about here. Yes, I have. I will tell you, I love being in tribal court because tribal court actually, I think, looks at the best interest of those kids, and they think outside the box a lot more. So when Chairman Finley talks about thinking outside the box, tribal courts do that all the time. They get to be creative. They get to think about what the needs are of that child. I have had difficulty transferring them because often the state doesn't want to transfer. So I never understood this because when I was a judge, those were not my favorite cases. I'm going to tell you, dependency neglect cases are not fun cases. So I'm always amazed when state court judges want to keep those cases, but they do. They don't transfer them. And the preference should be to transfer them because the tribes really do know what's in the best interest, and they also know who extended family are, and it's an environment where you can get a lot more done, I think. Just for example, like I said, they allow for suspension of parental rights, which allows for different kind of placement options than you're going to have in the state. Parents may be willing to say, I can't take care of my child right now, but in 5 years maybe I can. And that suspension of parental rights recognizes that and doesn't totally sever that relationship. So it just depends on what court you're working with, their willingness to transfer. But tribal courts are challenging, but they're no more challenging than the state courts. So it's just a different system. Go ahead.
Excuse me, in Montana, how interested have been tribal courts, tribal governments in cases that arise off the reservation but involving a tribal member?
Well, I actually think tribes are really interested in their children. What you're going to see is it's a resource issue for a lot of tribes. Tribes will often intervene, but they may not have the resources to provide the services that the family needs, so they won't request a transfer, but they'll be involved in the case. One of the things, and Nathan will be happy to hear this, I know, is under the new guidelines, that transfer can occur at any point in the proceedings. So Nathan had a case where he was making that argument, and the Montana Supreme Court said, no, it's too advanced in the proceedings. We're not going to transfer to the tribe. Under the new guidelines, you would transfer it. That isn't a bar to transferring it. So I think tribes are probably not as interested in getting involved, but once the parental rights have been terminated, they're very interested in where that child goes. So it's sort of an increasing interest the closest you get towards state determination that the rights are going to be terminated. And once they're terminated, I think the tribes really do have a significant interest then on where that child is going to be placed. Under the new guidelines, that case could now transfer. I think it always could. But now under the new guidelines, it's clear that that case can transfer even after the point of termination. Way in the back.
Is there some written guideline for good enough to help
Good enough.
people who don't know what that means? Should a case not go back to a tribal court that's kind of stuck in the state? For those of us who really care about preserving Indian families, how can we understand what constitutes an okay enough place for a child to be according to Indians?
Well, no. Evelyn did not draft any guidelines on good enough, unfortunately. But I think when you say, when do you decide when a case goes back? My position is anytime a tribe asks to take a case back, you transfer it because the tribe has an interest in its citizens. And those children are its citizens. So anytime there's a request to transfer, I think you just grant it. You don't, but that doesn't happen. I'm going to tell you that does not happen. So I think one of the factors that you're going to have to look at is what are the risk factors of the child being returned to the family. But one of the other things that I think gets lost is knowing how to work with Indian families and identify potential placements for that Indian family. It's not really easy for Indian families to work with state agencies for a variety of reasons, and that often is a barrier to identifying potential placements. Patty LaPlante, who has done a lot in the area of social work, made the suggestion, and I think it's a really good suggestion. When you're trying to identify extended families, what you do is you identify all the families that have connections to that tribe, and you ask them to submit 3 names of possible people that could be considered as an extended placement or a placement for this child. And what you're going to find is probably you're going to have at least 2 names that everybody agrees on. And that's a way of getting the families to engage that's more culturally, I think, consistent with how they would make decisions. But unfortunately, good enough is subjective. Yeah.
What about when a child, the mother is a federally recognized tribal member, but the child has not been enrolled, and there's the uncertainty, and yet because mother is, they most likely could be?
Okay, so it doesn't have to be enrolled. The Act says member, and member isn't the same as enrollment. If you've got a child that's enrolled, they're clearly a member, but you have children that are not enrolled that are still viewed as members. That's a tribal determination. You need to get the tribe to say yay or nay that this is a member, and that's the final determination of whether the child is a member. I think I'm out of time, aren't I? One other question? Was there, no? Okay. Okay.